What if I told you that right now, this very month, there are immigration doors opening that haven't been this wide in years? Doors that could bring families together. Doors that could turn temporary work into permanent residence. Doors that could finally offer relief to people who've been waiting in uncertainty for months, even years. And here's the thing. Most people have no idea these opportunities even exist. They're not being talked about enough. They're not making headlines. But for the right people, green card holders, skilled workers, asylum seekers, and hundreds of thousands who entered legally but were left in limbo, this month could be life-changing. If you know what to do, if you act fast, if you understand exactly how these opportunities work and why timing matters more than ever. So today, we're breaking down 4 major wins happening right now in immigration. 4 categories of people who can take action immediately.
4 pathways that are suddenly open or reopened after being closed or delayed for far too long. And if you or someone you know falls into any of these groups, what you're about to learn could be the difference between staying stuck and finally moving forward. Let's dive in. Win number 1. Green card holders can now petition for their spouses immediately. This is huge, and if you're a green card holder with a spouse waiting to join you in the United States, you need to pay close attention. Here's the background. Normally, when a green card holder wants to bring their spouse to the U.S., they file a petition. That petition goes into a category called F2A, and historically there's been a waiting period. Sometimes months, sometimes years, depending on where you're from. You file the petition, and then you wait for a visa number to become available. Only then can your spouse move forward with adjusting their status or going through consular processing. But right now, in April, the F2A category is current. What does current mean? It means there's no waiting period. It means that if you're a green card holder and you file a petition for your spouse, you can also file for their adjustment of status at the same time, just like a U.S. citizen would. This is not normal. This doesn't happen all the time, and it's especially significant for people from countries that usually face long backlogs, like India and China. So if you're a green card holder and your spouse is in the United States in legal status, this is your moment. You can file the petition and the adjustment application together. Your spouse could get a work permit in a matter of months. They could get their green card without having to wait years in limbo. Now here's the catch, and it's important. Your spouse must be in the U.S. in legal status. That could mean they're here on a work visa, a student visa, or even a visitor visa that's still valid. But they cannot be here unlawfully. If they entered without inspection, or if their status has expired and they've overstayed, this process won't work for them. Legal status is the key, but if that box is checked, this is one of the best opportunities green card holders have had in years. So what do you need to do? You need to file 2 forms. First, the petition itself, Form I-130. This establishes the relationship between you and your spouse. You'll need to provide proof that your marriage is genuine. That means marriage certificates, joint financial documents, photos together, affidavits from people who know you as a couple. The goal is to prove that this is a real, bona fide marriage, not something done just to get immigration benefits. Second, you file Form I-485, the application to adjust status. This is what actually changes your spouse's status from a temporary visa holder to a lawful permanent resident. Because the F2A category is current, both forms can be filed at the same time, and that speeds up the entire process dramatically. Your spouse will also be able to apply for a work permit and travel authorization while the green card application is pending. That means they're not stuck waiting without the ability to work or leave the country. They can move forward with their life while the case is being processed. This is a rare and valuable window, and it may not stay open forever. Visa bulletin categories shift every month. What's current today might not be current next month. So if this applies to you, don't wait. Gather your documents, prepare your forms, file as soon as possible. Win number 2. Employment-based green cards are moving forward. EB2 and EB3 categories are current. Now let's talk about people who are in the U.S. on work visas or who have employers willing to sponsor them for permanent residence. This is another major development. The EB2 and EB3 categories are now current. Let me explain what that means. EB2 is the employment-based second preference category. It's for workers who have advanced degrees or exceptional ability in their field. EB3 is the employment-based third preference category. It's for skilled workers, professionals, and other workers who may not have advanced degrees but have valuable experience. Normally, Even after an employer sponsors you, there's a waiting period before you can apply for your green card. You're given a priority date, and you wait until that date becomes current. For some countries, again, India and China in particular, that wait can be years. But right now, both EB2 and EB3 are current. That means if your employer has already filed a labor certification and an immigrant petition for you, you can now file your adjustment of status application. You don't have to wait anymore. And if you're an employer trying to retain talented workers, this is your opportunity to move them toward permanent residence quickly. Here's how the process works. First, the employer has to prove that they need to hire a foreign worker because there are no qualified U.S. workers available for the job. This is done through a process called labor certification, or PERM. The employer advertises the job, they document their recruitment efforts, they show that no U.S. worker applied or was qualified. Once that's approved, the employer files Form I-140, the immigrant petition for the worker. This establishes that the worker meets the qualifications for the job and that the employer is offering them a permanent position. Once the I-140 is approved and the category is current, the worker can file Form I-485 to adjust their status. And just like with family-based cases, the worker can apply for a work permit and travel authorization while waiting. This is a game changer for people who have been stuck on temporary work visas like H-1B, because those visas have time limits, and if you can't adjust your status before your visa runs out, you could be forced to leave the country. But now, if your employer is willing to sponsor you and the category is current, you can move toward permanent residence without the uncertainty of waiting years. For employers, this is also a huge benefit because it allows you to secure the talent you need without worrying about losing them due to visa expirations. It gives your employees stability and it gives your business continuity. So if you're an employee who's been waiting, now is the time to talk to your employer about moving forward. And if you're an employer who's been holding off on sponsoring someone, now is the time to act. Win number 3. Asylum processing has resumed with conditions. This one is more limited, but it's still significant. For months, asylum processing in the United States has been largely paused. Applications were sitting untouched. Interviews weren't being scheduled. People who had fled dangerous situations were left in legal limbo, unsure of what would happen next. But now, the administration has announced that asylum processing is resuming. However, and this is important, it's not resuming for everyone. The administration has said that processing will restart for asylum seekers from what they're calling low-risk countries. What does that mean? It means the government is making a distinction between people coming from countries they consider stable or low threat versus those coming from countries they view as high risk. The criteria for what makes a country low risk versus high risk hasn't been fully spelled out yet, and that's going to be a source of confusion and concern for many people. But the key point is this. If you're an asylum seeker who applied and your case has been sitting inactive, there's now movement. If you're from a country that's categorized as low risk, your case may start moving forward. You may finally get an interview scheduled. You may finally get a decision. And that means you can start planning your life again. Now, if you're in this category, here's what you need to do. First, make sure your application is as strong as possible. A lot of asylum cases were filed quickly, under pressure, without a lot of supporting evidence. Now is the time to strengthen your case. Gather affidavits from people who know your story. Get updated country condition reports that show the dangers you would face if you returned. Document everything that supports your claim: membership in a persecuted group, threats you received, harm you suffered, lack of government protection. Second, be prepared for your interview. Asylum cases are often won or lost based on credibility. The officer or judge needs to believe your story. That means you need to be consistent, detailed, and honest. You need to be able to explain what happened to you, why you're afraid to return, and why your government can't or won't protect you. If you're not comfortable speaking English, make sure you have a qualified interpreter. If you're not sure how to prepare, consider working with someone who understands asylum law, because this is your chance. If processing is resuming, you don't want to waste it with a weak application or a poorly prepared interview. Win number 4, 900,000 people who entered on parole through CBP One may get relief. This one is about a court decision, and it affects hundreds of thousands of people who entered the United States legally under a program created during the previous administration. Here's the background. Under the Biden administration, a program was created that allowed certain migrants to schedule appointments at the border using an app called CBP One. If approved, they were allowed to enter the United States on parole. Parole is a legal status. It's temporary, but it's legal. It allows someone to be in the U.S. while they pursue other forms of relief, like Asylum. About 900,000 people entered through this program. They were vetted, they were screened, they followed the process. But when the administration changed, the new government took a different view. They began sending letters to people who had entered on parole, telling them their status was revoked. Some were told to leave the country, some were even deported, and that created chaos, because these people had done everything legally. They had followed the rules, and now they were being told they had no right to be here. But a federal judge has now ruled that this revocation was unconstitutional. The judge said that the government cannot simply take away someone's legal status after the fact without due process, and that means those 900,000 people may now have their status reinstated. So if you're one of those people, here's what this means for you. First, you may be able to come out of the shadows if you've been hiding. You entered legally. A court has now said your status should not have been taken away. That gives you a legal basis to stay. Second, if you haven't filed for asylum yet, now may be the time, because parole gives you the ability to be in the U.S. while you pursue other relief. And with asylum processing resuming for certain groups, this could be your pathway to stability. Third, if you were deported or left the country because of the revocation, you may have legal options to return or challenge what happened. This is still developing, but it's a significant win, and it shows that the courts are still willing to step in when the government oversteps. Why these 4 wins matter, and why you need to act now. So let's step back and look at the bigger picture. Why are these 4 developments so important? Because they represent opportunities that don't come around often. Immigration law is slow, it's bureaucratic, it's full of waiting periods, backlogs, and uncertainty. But every once in a while, things line up, categories become current, processing resumes, courts issue rulings. And when that happens, you have to move fast. Because these windows don't stay open forever. Visa bulletins change every month. Policies shift with new administrations. Court decisions get appealed. So if you're in one of these 4 groups, the time to act is now. If you're a green card holder with a spouse in the U.S., file your petition and adjustment application now. If you're a worker whose employer is willing to sponsor you, start the process now. If you're an asylum seeker from a low-risk country, strengthen your case now. If you entered on parole through CBP One, understand your rights now. Don't wait. Don't assume the opportunity will still be there next month. Don't assume someone will notify you when it's time to move. You have to take responsibility for your own case. You have to stay informed. You have to act. And if you're not sure how to move forward, get help. Talk to someone who understands immigration law. Make sure your applications are complete and accurate. Make sure you're not missing deadlines or making mistakes that could cost you everything. Because immigration is unforgiving. One mistake can delay your case for months. One missed deadline can close a door that might not open again. But if you act carefully, thoughtfully, and quickly, these 4 wins could change your life. They could reunite your family. They could secure your job and your future. They could give you the legal stability you've been waiting for. So take this seriously. Take it personally. And take action, because right now, the doors are open, and you don't want to be the one standing outside when they close.